1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်180 GYEE HOKE and 6 others appellants versus SHAN and 4 others respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးထွန်းတင် and ဦးစိန်သင်ခြေGYEE HOKE and 6 others appellants versus SHAN and 4 others respondents suit for dissolution of partnership and for rendition of accounts of a partnership fund, dissolution of the partnership by the death of a partner, continual enjoyment of the benefits of the partnership by the wife of the deceased partner, whether conclusive proof of a new partnership, intention of the parties to be gathered from their contact. The plaintiff, the first respondent, finds a suit for dissolution of partnership and for rendition of accounts in respect of a partnership fund by the name of Sin and Chun, which was started some 17 years ago by two partners, Ko Phan Pan of the Ko family and Wibo A of the Wee family, the latter being the father of the plaintiff. Wibo A died in 1892. Hell, the partnership between Ko Phan Pan and Wibo A was dissolved by the death of the latter, no matter what might have been their intention regarding the continuance of the fund, as the partnership consisted of two persons only. This does not, however, preclude the possibility of a new partnership coming into existence by means of a contract, either express or implied, between Ko Phan Pan and Cat, widow of the deceased partners, but there is no evidence to prove an express contract between them. The evidence obtaining on the record of the trial court clearly showed that after the death of Wibo A, his widow Cat did enjoy the benefits of the business of Sin and Chun, even conceding that Cat enjoyed a defined share of the profits of the business of Sin and Chun. This fact by itself is not conclusive proof of a new partnership. It is clear that the most important factor in determining the existence of partnership is the intention of the parties to be gathered in the absence of a written instrument by the content of the parties, and Ko Phan Pan contact since the time of Wibo A death had all along been in the nature of a sole proprietorship. Therefore, in the absence of any testimony regarding agreement between Cat and Ko Phan Pan, it cannot be held that Cat became a partner merely because she suffered her property to be utilized in the business, and a fortiori that the plaintiff, the first respondent, ever became a partner after his father's demise. Ram Kumar vs. Kishore ILR All Series 1946 309 descended from MT Sukra and others vs. Babu AIR 1952 All 506 K. Haji Abdul Latif Sahib vs. the official assignee of Madra ILR Met Series Volume 51, 1928, page 308, Habit Best vs. Samuel Fit Company, AIR, 1926, or 161, Radha Kishandas vs. Kankabia, AIR, 1927, scene 218, refer to Mr. L. Hossein for the appellants, Ujomye for the respondent number 1, U Padato for the respondent number 2, 3, 4. U Saintin Judge in Civil Regular Suit number 671 of 1962 of the City Civil Court, Rangoon, the plaintiff Wee Shan, who is the first respondent in this appeal, finds a suit for dissolution of partnership and for rendition of accounts in respect of a partnership fund by the name of Sin Chun. The fund was started some 70 years ago by two partners, Go Ban Ban of the Go family and Wee Bo E of the Wee family, the latter being the father of the plaintiff, Wee Shan. In 1892, Wee Bo E died, leaving him surviving his wife, Docket, and 3 minor sons, including the plaintiff Wee Shan. After Wee Bo E death, Go Ban Ban alone carried on the business. Go Ban Ban also continued to look after Docket and her children. In course of time, Go Ban Ban was assisted in his business by his two elder sons, HOKE and Chuan, the first and the second defendants appellants, as well as by Wee Ko, elder brother of Wee Shan. Go Ban Ban died in 1930, leaving behind a will, by which he appointed the aforesaid 3 persons to be his executors and trustees to manage and conduct the business of Sin Chun, which was accordingly carried out. In 1914, Docket died, but her death did not affect the conduct of the business of Sin Chun. Then in 1957, Wee Ko died. His death was followed by a series of correspondence between Wee Shan on one hand and HOKE and Chuan on the other, indicating strained relationship between them, which finally touched off the present suit under appeal, in which all other surviving heirs of the two original partners are joined as parties. The plaintiff Wee Shan case is that the original partnership formed by Go Ban Ban and Wee Bo E has never been dissolved since its inception. It is asserted that on Wee Bo E death, Docket became a partner and that the partnership was later strengthened by the admission of himself and his brother Wee Ko. According to the plaintiff, the partnership was also not dissolved either on the death of Go Ban Ban in 1930 or of Docket in 1914. He would have the court hold that on the death of each partner, his or her heirs, along with the other surviving partners, continued the old partnership business with the old partnership assets, enjoying the same rights and liabilities as before. The gravamen of the defense, however, is that although the business of Sin Chun continued for some time, the original partnership had been dissolved as early as 1892, when one of the two founder partners, viz. Weibo died. It is emphatically denied that Dorcas or any of her sons was ever admitted into the partnership. Thus, one of the issues in the lower court is whether Dorcas became a partner in the fund of St. Chun on the death of Weibo. It is common ground that Weibo died in the year 1892. Therefore, the question whether the partnership was dissolved or not must be determined according to the law in force at that time. As rightly pointed out by the lower court, the law regarding partnership then prevailing was Section 253 of the Contract Act, which was Act number 9 of 1872, but there is hardly any appreciable difference between this section and Section 42 of the Partnership Act, insofar as the dissolution of partnership is concerned. Under both the laws, a partnership is dissolved in the absence of any contract to the contrary by the death of a partner. Thus, if there has been a contract between the parties that the partnership would not be dissolved on the death of any of the partners, the dissolution will not take place in spite of the death of a partner. Citing various authorities, the land trial judge was of opinion that the existence of such a contract may be proved either by an express declaration to that effect or may be determined from the conduct of the parties. The lower court has taken great pains in considering the voluminous evidence adduced by the parties. After carefully weighing the evidence, he came to the findings that for a period of over 40 years after Weibo's death, Go Pan continued to carry on the business of St. Chun, that Go Pan not only took upon himself the sole responsibility of conducting the business, but also looked after the surviving members of Weibo's family as if they were his own. That neither Dorcas nor any of his sons ever demanded partition of the partnership properties, but simply acquiesced in Go Pan carrying on the business all by himself, and that there was a strong tie between the two families. Based on these findings, the land trial judge inferred that there had been a contract between the original partners, that the partnership was not to be dissolved by the death of any of them. He therefore held that on the death of Weibo, the partnership was not dissolved and that a family partnership came into being with Dorcas, representing the Wee family in place of her deceased husband. The assertion regarding the existence of a family partnership business, according to Chinese customary law, has since been abandoned by the Land Council for the second, third, and fourth respondents. 5 Diary Entry, date 4 April 1967. Thus, the only question left to be considered is whether the partnership was dissolved by the death of Weibo. As pointed out by the land trial judge, there are no top circumstances indicating that the original partners might have intended to continue the partnership even after the death of any one of them, but the question whether the partnership was dissolved or not was entirely independent of the intention of the original partners. It must be remembered that the original partnership consisted of only two persons. Therefore, even if they had intended their partnership to be continued after the death of any one of them, no valid contract would have been possible between them to that effect. For neither party could, by his contract, impose a partnership upon his heirs or legal representative, partnership being a matter of contract and not of status. The following observation, which occurred in the case of M.T. Sugara and others versus Babu 1 are opposites. When it is said that a partnership will not be dissolved by the death of one party, what is meant is that the partnership will continue between the surviving partners even after the death of a partner. It follows that in order that the exception to the general rule may apply, the original partnership must consist of more than two partners. In the case of a partnership consisting of only two partners, no partnership remains on the death of one of them, and therefore it is a contradiction in terms to say that there can be a contract between two partners to the effect that on the death of one of them, the partnership will not be dissolved but will continue. Nor is the position affected by bringing in the heirs of a deceased partner on the sense. One partner cannot, by his own contract, impose a partnership upon his heirs or legal representative. Partnership is not a matter of status, it is a matter of contract. No heirs can be said to become a partner with another person without his own consent, express or implied. The trial court has had the advantage of the ruling cited above, but it appears that the land judge has failed to comprehend the full import of the dictum laid down therein. This ruling is an explicit authority for the proposition that in a partnership consisting of two partners only, the dissolution of partnership takes place by the death of a partner, notwithstanding their intention to the contrary, for the simple reason that it is impossible for the partners to make such a contract. In other words, a partnership consisting of two partners only is dissolved by the death of a partner, and its continuance cannot, under any circumstance, be inferred by the contact of the partners. No doubt in Ramkumar vs. Kishore 2, where the partnership consisted of two persons only, it was held that the death of a partner need not necessarily cause the dissolution of a fund, and that was subject to a contract between the parties in Section 42 of the Partnership Act do not require that there should be an express contract, but this has been descended from in M.T. Sugara case cited above, where the fallacy of the argument that there can be an implied contract between the original partners is exposed on the ground of a partner's disability by his own contract to impose a partnership upon a third person. Thus, in the instant case before us, we are of opinion that the partnership between Go Pan Ban and Weibo was dissolved by the death of the latter, no matter what might have been their intention regarding the continuance of the fund. This does not, however, preclude the possibility of a new partnership coming into existence by means of a contract, either express or implied, between Go Pan Ban and HOKE. But it is never the case of the plaintiff that his mother, HOKE, became a partner by virtue of such a contract. He has consistently taken the stand that on Weibo's death, HOKE, by reason of her position as the head of the Wee family, became a partner in the fund, which was never dissolved. In spite of the plaintiff's assertion to the contrary, we have carefully considered whether after the dissolution of the original partnership, a new partnership came into being between Go Pan Ban and HOKE. There is undoubtedly no evidence to prove an express contract between them, but as pointed out in Ram Kumar case already referred to, such a contract may be construed by implication. It therefore remains to be considered whether a fresh contract to continue the business of St. Anton in partnership could be inferred from the conduct of the parties. The evidence obtained on the record of the trial court clearly showed that after the death of Weibo, his widow HOKE did enjoy the benefits of the business of St. Anton. It is also common ground that her children as well as those of Go Pan Ban were educated out of the fence of St. Anton, but these facts, apart from demonstrating the fair-mindedness of Go Pan Ban, do not go so far as to prove the existence of a contract, either express or implied, between Go Pan Ban and HOKE to continue the business of St. Anton in partnership between them. For even conceding that HOKE enjoyed a defined share of the profits of the business of St. Anton, this fact by itself is not conclusive proof of the partnership. In the case of K. Haji Abdul Latif Sahid versus the official assignee of Madras 3, it was held that a person who merely deposited money in the fund and received from the fund a certain share of the net profits, and as between whom and the fund there do not exist the ordinary incidents of partnership, such as the right to participate in the management of the partnership business or the dissolution of the partnership on his death or retirement, is not a partner of the fund. The same opinion was expressed in Habib Bas versus Samuel Fish and Company 4, where it was laid down that the right to participate in the profits of trade is in itself a strong test of partnership, but participation in profits, although strong evidence, is not conclusive evidence of a partnership, and the question of partnership must be decided by the intention of the parties to be ascertained from the contents of the written instrument. If any, and the content of the parties, thus it is clear that the most important factor in determining the existence of partnership is the intention of the parties to be gathered in the absence of a written instrument. By the content of the parties, in the present case before us, Ko Phan Ban, after the death of Weepo, carried on the business of Sin and Chun without the active participation of anyone, although after some time he enlisted the assistance of his two sons and Wee Tin Ko. Docket did not feature in any of the activities of Sin and Chun, nor was she consulted when Ko Phan Ban made his will by which he made over the business of Sin and Chun to his two elder sons and Wee Tin Ko, who were appointed his executor and trustee. No allusion whatsoever was made in the will either to Docket or her late husband. Ko Phan Ban conduct, since the time of Weepo death, had all along been in the nature of a sole proprietorship. It is true that there is no evidence regarding partition of the partnership property after the death of Weepo. Therefore, it seems probable that Docket, as the legal representative of her husband, might have allowed her share of the property left behind by the deceased to be used in the business of Sin and Chun. But in the absence of any testimony regarding agreement between Docket and Ko Phan Ban, it cannot be held that Docket became a partner merely because she suffered her property to be utilized in the business. This is the view expressed in Radha Kishandas vs. Kankabai 5, and with respect, we are of the same opinion. Thus, it seems clear to us that from the material obtaining on the record of the trial court, no partnership can be construed as between Ko Phan Ban and Docket after the death of Weepo, a fortiori that Wee Tin Shan ever became a partner after his father's demise. The defendants' appellants, HOKE and Chuan, by their written statement assert that a new partnership came into being as a result of the will left behind by Ko Phan Ban, and that the partnership so settled had been, by consent of the partners, dissolved in the year 1952. In spite of the copious evidence on the record of the trial court regarding the alleged dissolution, we do not think it necessary to give serious consideration to this matter. It is not this alleged new partnership which the plaintiff is now seeking to dissolve, and in respect of which accounts are being asked for, even considering that there was such a partnership, the plaintiff would not be competent to sue for its dissolution, as he was not one of its partners. In any case, the sole basis of the alleged partnership being the will left behind by Ko Phan Ban, we are at a loss to understand how a partnership could have been established by way of testamentary disposition of property. In the result, we hold that no partnership exists between the plaintiff respondent Wee Shan and others in respect of the business of Sin and Chun. This appeal is therefore allowed. The judgment and decree passed by the lower court will be set aside with costs. Advocate fee fixed as 5 gold mohars.